can sit. You don't have to. I don't think any of us know what the right thing is to do. You can sit.
We were just, there we go.
All right, welcome, counsel. Looks like we're prepared to proceed, so we'll move to our next case on the calendar, which is number 2218, Butterfield versus Shaw. The appellant's ready. You may proceed.
With the court's indulgence, may I unmask?
Yes.
And I'd like to reserve, with the court's indulgence, 6 minutes for rebuttal, if possible. Judge Collins, Judge Dietz, and Judge Zachary, may it please the court, my name is Brad Wood. I'm from Winston-Salem, and I'm here on behalf of the appellants in this case, at least the appealing parties. It's an interlocutory appeal, but I represent the County of Wilson, North Carolina, its duly elected sheriff, who's Calvin Woodard, and 2 of his detention officers. Their names are Vicky Shaw and R.D. Adcock. And it's their appeal of an order by Judge Alan Badur in Orange, well, it was from Orange County, but in Wilson County, denying their motions for summary judgment, which were advanced on the grounds of governmental immunity, as well as the plaintiff's constitutional claim, North Carolina constitutional claim, being barred because they have adequate state remedies available to them. So to give a brief background, the plaintiff's claims are premised upon the death of their decedent, Todd Cavanis, who passed away several days after being transferred from the Wilson County Jail to the Wilson County Hospital. The plaintiffs are essentially alleging that Mr. Cavanis did not receive proper medical attention and care, and that he should have been transported from the jail to the hospital earlier than he was. They've sued my clients, as I said, Wilson County, the sheriff, who is the custodian of the detention center where Mr. Cavanis was being detained pending, I think he'd been charged with a non-fatal shooting of someone in Wilson, as well as the 2 detention officers. They have also sued Southern Health Partners, which is the contracted medical care provider for the Wilson County Detention Center, as well as one of the Southern Health Partners nurses, Haley Gray, and those parties are not parties to this appeal. We move for summary judgment, as I said, as to the claims against Wilson County. The plaintiffs have, at least as it pertains to my clients, as I read it, at least four causes of action in the complaint. They have, as their third claim, it's styled as negligence and wanton conduct against the detention officers, Adcock and Shaw. Then they've sued the sheriff as well in their fourth claim in his official capacity as well as in his individual capacity. And subsumed into that cause of action is also a statutory claim against Sheriff Woodard's official bond, pursuant to North Carolina General Statute 58-76.5. Their fifth cause of action is a constitutional claim. And again, I direct the court, this is a state constitutional claim. They have specifically in their complaint disclaimed any federal claims under the Section 1983 or otherwise. And then their sixth cause of action is styled as liability of Wilson County. And so we had a hearing in Wilson County, and Judge Badur issued an order in which he denied my client's motions, did not go into why, but I am seeking a reversal of that order and that all the claims against Wilson County be reversed, and that the claims against Sheriff Woodard and his 2 detention officers, Adcock and Shaw, in their official capacities, that those denials of their motion for summary judgment on the basis of governmental immunity also be reversed. What we do not claim to have governmental immunity to is the statutory claim on the sheriff's bond pursuant to North Carolina General Statute 162-8. Every sheriff in the state has to have an official bond, but that statute also prohibits that bond from being any more than $25,000. That's what our General Assembly has determined to be adequate and appropriate in this situation. The sheriff's bond in this particular case is $20,000. That's consistent with the statute. So there was a hearing held, and the judge, as I said, denied our motion for summary judgment. And
So in your view, are there, just so I understand, was your summary judgment motion to see, were there independent claims that you were seeking to have dismissed beyond the claim on the bond, or were you seeking to have an order on summary judgment that said you can only recover on the statutory claim and up to this amount and no more? What exactly was, because we can read your motion and then we have just we have an order that just says that the summary judgment is denied, so we don't really know what the trial court's reasoning was.
That's correct, Your Honor. What we're seeking is essentially all the claims, and it's hard for me to parse it out because their claim against the sheriff was subsumed together. But what I am arguing to this court is that all the claims against Wilson County, because there's no bond in question for a county, and that all the official capacity claims against the sheriff and his 2 detention officers, who in their official capacities are essentially, they are part and parcel with the sheriff, that all those claims be dismissed as being barred by governmental immunity, with the exception of the statutory claim on the bond, which would be, in this instance, for $20,000. And I don't know if I've answered Your Honor.
Well, I'm just trying to understand, when looking at the claims in the complaint, like so your view is there are separate, the statutory claim is separate, can be divided out, and then there's other claims that can be dismissed on summary judgment if we conclude there's, and what you were really just seeking there is everything other than this bond claim we're seeking to have dismissed. Is that?
I think that's a fair assessment of our position, Your Honor.
Okay.
So,
And let me just interject, there's also a direct constitutional claim, and you sought to have that dismissed, and that was denied as well.
that's correct, Your Honor.
And have you argued on appeal that that should be dismissed as well?
Yes, we have.
Have you asserted a substantial right in that? Because I didn't read that in your brief.
Substantial right that be heard today?
Yes, no substantial right that it be heard on appeal, because obviously it's interlocutory, the denial.
It is an interlocutory appeal, and I don't believe that we did that, Your Honor. I think as a matter of judicial economy, because we're dealing strictly with a legal issue, is there not an adequate remedy at law? And under the case law of this state, I don't think it can be reasonably disputed that there is not for the plaintiffs, which renders their constitutional claim barred. So, but I'd first like to address the claims against Wilson County. A lot of mileage was spent, I guess, in both the brief and some of the oral argument with the judge. The way the plaintiffs pled their claim against Wilson County was that the sheriff was an employee of Wilson County, and that the detention officers also were employees of the county, and that the county was responsible for the jail. I think all those are clearly erroneous. The sheriff is a constitutional officer elected by the citizens of the county and is not an employee of the county. While the county obviously funds the sheriff's office because they have the means to do so, the sheriff has no means to levy taxes. But the sheriff is an independent individual and not an employee of the county, and by the same token, his detention officers are not employees of the county, but rather him. So having said all that, that was part of the reason why that's how the plaintiffs pled the liability of Wilson County. But beyond that, governmental immunity, they have, and it's in the record on appeal, and I've cited the particular exclusions in our brief, but contained in the contract that Wilson County has with the North Carolina Association of County Commissioners are set forth numerous exclusions, one of which specifically preserves governmental immunity, or it does not cover claims that would otherwise be barred by governmental immunity. And that language has been upheld on numerous occasions by this court. It's really not in dispute. I've listed some of the cases, but going back as far as 2010 to 2012. And the language in this policy is identical to, say, the ones in Early versus the County of Haywood, and I believe there's several others. There's really no difference. And so the rulings in that case holding that this language actually preserves governmental immunity, that applies to this case as well. So, of course, governmental immunity is it's the policy of our state. I cited several cases from our Supreme Court that go back pretty far, some as far as 1947, and more recently, some of the ones from 1970s. But it is the policy of our state. There is a statute, it's 153A-453, where it allows a county to waive governmental immunity by the purchase of insurance, but it's clear within that statute that the waiver of governmental immunity is limited solely to the coverage provided. So if there is no coverage for the particular claim in question, then governmental immunity has not been waived. And so that's why Wilson County is entitled to governmental immunity in this case, is because the insurance policy or the contract that they have with the North Carolina Association of County Commissioners preserves governmental immunity. And so the claims against Wilson County, even if you get past the fact that they're not responsible for the sheriff and his detention officers, even if they were, those claims would be barred by governmental immunity. And I know the plaintiffs in their brief go into some detail about duties owed to inmates to provide medical care, but that duty, whether it's non-delegable or not, doesn't overcome governmental immunity, which is it's not just a defense, it is a pure immunity from suit. So for the reasons that I've said, barring your questions, that addresses my argument with respect to Wilson County. And then moving on to the sheriff and his detention officers, there's two ways that a sheriff can waive governmental immunity. One is what I just described, is to be covered under an insurance policy under 153A-453, or by purchasing an official bond, which, as I said earlier, they must do under North Carolina statute. But the cases are clear, again, with respect to an insurance policy, whether they get it themselves or whether the county furnishes it and funds it in this particular case. Their waiver under that prong of governmental immunity only goes so far as there is coverage for any claims against them. And again, for the same reasons that I described with respect to Wilson County, the same exclusions apply. There's a different section in the policy that applies to law enforcement officers, but the exclusions are essentially identical, and they are identical to the ones I described earlier that this court in State v. Early and Owen versus the city of Haywood County, and forgive me for forgetting some of the other cases, but all the language preserves governmental immunity. So there's no waiver of governmental immunity by the purchase of an insurance policy with regard to the sheriff in this case. On the other hand, there is the statutory bond, which we don't sit here and argue with you that there's been waiver to that. And back to your point, Judge Dietz, that's essentially, we concede that there is a waiver to a claim against the bond, a statutory claim, which I think is separate than any other claim. But again, that is limited by the amount of the bond, which again in this case is $20,000. And so for that reason, I think respectfully that the Judge Badur erred in denying summary judgment in favor of Sheriff Woodard in his official capacity, as well as those of his detention officers, with respect to everything other than the sheriff's bond in the amount of $20,000. And then with respect to the constitutional claims, it's clear that you only have a direct claim under the North Carolina Constitution if you don't have an adequate remedy otherwise available to you. And the plaintiffs clearly have multiple alternate available remedies, some of which they've asserted and some of which they've chosen not to. And I'll point out that they have sued Southern Health Partners, which is insured for $1 million. I think that's equivalent to the State Tort Claims Act, not an inconsequential amount. They've also sued Haley Gray, both officially and in her individual capacity. And further, they've sued, again, Sheriff Woodard in his individual capacity and the two detention officers in their respective individual capacities. And the cases are legion from this court, which have not been disturbed by our Supreme Court, that individual capacity claims are an adequate remedy at state law sufficient to bar a direct claim under the North Carolina Constitution. There's the DeBond versus, and I'll butcher the last name of the defendant in the case, Courage, I believe, the Wilcox case. There's, I guess, Rosillo versus Starling, and another case.
Does that have to be an individual capacity suit against the same person that could, in their official capacity, have been sued on the constitutional claim? You know, in other words, the state actor and not someone else? 'Cause I think one argument we're going to hear from your friend from the appellee here is that these are not adequate remedies to sue these other joint tortfeasors because they want justice against the government employees here that violated what they've said are these constitutional rights, and so those remedies are not sufficient there. What's your response to that?
Well, my response is that the law doesn't support their position. There's at least two cases that from this court, one of them is quite recent. The Taylor case, I believe it's versus the city of, I'm embarrassed, I can't remember, Taylor versus Wake County, where in that case it was a department, it was a social workers case. The facts were quite disturbing. As I read the facts, apparently the social workers somehow made a judgment call or did something improper, and a deranged father shot the grandparents and shot the mother, who ended up bringing suit, but shot these people in front of their children. So the plaintiffs in that case, or the plaintiff, who was the guardian of the child and also the victim of the shooting, brought suit against two entities, one against the state, the DHHS, and also brought suit against Wake County. And the court held that because she had a remedy against the state, and I believe in that case the state also had governmental immunity, or something against that barred that claim against the county, pardon me, but she had an
you had the State Tort Claims Act case, right, where there that you could go and you could, there'd been a waiver of sovereign immunity to go through the Tort Claims Act to bring that claim.
Right.
But my question, or my observation about that case is that our municipal governments are still arms of the state. I mean, so in that case you have these different actors, but you're all sort of dealing with the state. And I think one of the arguments we're going to hear from your friend appellee is the claims that, at least in your view, are the ones that don't have any issues with sovereign immunity can go forward are against third parties who are not the state, or are not part of the sheriff's office. So that's why it's not an adequate remedy, because suing other joint tortfeasors who are private citizens does not remedy the constitutional violation. So what's your best argument for why that should not be how the law functions here?
Well, again, because I don't believe the cases that we're discussing support that. I'll refer you to, and I hate to quote from the case, but I will because I think it's instructive here. In the Taylor case, this is what this court said: the adequacy of a state law remedy depends upon the injury alleged by the plaintiff, rather than upon the party from whom a plaintiff seeks recovery. And there's a similar type of claim in the Rossello versus Starling case, which was a case in which a person believed that they were improperly stopped and searched and asserted a state constitutional claim, but the court held that because they had an individual capacity claim against the trooper that stopped them, that barred their state constitutional claim. But the court in that case, this court said, Rossello first contends that such common law remedy is inadequate because he could not assert his claim against the state of North Carolina. So in that case, just like you're describing here, Your Honor, the plaintiff would like to go after this particular person for justice, but that's not what the law says. It says if you can basically go after anybody else for that injury in question. It's the injury, it's the violation of your constitutional right, not necessarily who you would like to sue. And so in this case, the injury that the case we're talking about here today, the injury that the plaintiffs are seeking to have remedy, they're seeking to seek damages for, is the wrongful death of Todd Cavanis. Well, they're suing Southern Health Partners for the wrongful death of Todd Cavanis for the very same thing, and they've got a remedy against them, and there's certainly no question of governmental immunity, and certainly no question that it's not a small amount of money. They've got also claims against the nurse, and as I said earlier, they do have individual capacity claims against the sheriff and his detention officers. There was kind of, I guess there's been some oxygen consumed by a lot of the briefing about whether or not the bond itself is if that's the only remedy you have, whether or not that's adequate under the law. There's a case that I cited, it's unpublished, it's the Causey case, which suggests that it is, but Your Honors, you don't need to reach that level because there are other adequate remedies in law in that, as I said, Southern Health Partners, the defendant, the nurse, and again, the individual capacity claims, all again for the same injury. So I don't know if I've adequately, I may not have convinced you, but hopefully I may have at least answered your question, sir, about that. I know I've reserved some time for rebuttal, but I think because I have some time, barring any questions from the court, to utilize that to address some of the points made by the plaintiff and the amicus for that reason. I mean, there seems to be a lot of urging by the plaintiffs to do away with the doctrine of governmental immunity. And respectfully, I don't think this court has the authority to do that, and I don't think the judiciary as a whole has a ability to do that. Of course, there's been numerous cases that have, from the North Carolina Court of Appeals, that have upheld the doctrine of governmental immunity, and so respectfully, this panel would not be in a position to overturn that. As you know better than I do, you're not in a position to overturn the Supreme Court of North Carolina, which has consistently held that governmental immunity is the policy and the doctrine of this state. And really, the proper, if somebody's going to overturn governmental immunity and abolish it, I think the Supreme Court said it right in our Supreme Court in the Steelman case years ago, Steelman versus the city of New Bern. It's from 1971. And the very last thing the court says, responding to an urge by the plaintiffs to dispel or to abolish governmental immunity, also sovereign immunity, it's the same doctrine. However, this is the court quoting, however, despite our sympathy for the plaintiff in this case, we feel that any further modification or the repeal of the doctrine of sovereign immunity should come from the General Assembly and not this court. So with all due respect to the judiciary and to the plaintiffs, I think if that's something that our state is going to decide is no longer a proper public policy, I think that's left to the people elected throughout our 100 counties. So I just addressed that quickly. Again, I've already talked to the point of, regardless of whether or not there's a duty to provide medical care, I mean, there's a statute that also authorizes you to contract out to private medical care providers, as was done in this case, because certainly sheriffs and detention officers are not qualified medical. I don't think you will find many registered nurses and doctors who decide to moonlight as detention officers. So you have the ability and the authorization from the General Assembly to contract out. But regardless of the duty to provide medical care to inmates, again, that duty does not overturn or override governmental immunity. I mean, again, it's immunity from suit, not from whether or not you've got a duty. So I just want to touch that. There's a couple of cases that the plaintiffs have submitted as what they, I think, recently decided by the North Carolina Supreme Court, and I just want to touch on them. The first case is the Minsky case. I believe I pronounced that right. And really all that goes to show is, again, if you don't have an alternate or an adequate remedy at law, then you can proceed with a state constitutional claim. And in the Minsky case, and I can find my notes properly, but I believe that the plaintiff in that case, a minor, was suing, contending that her right to an adequate education under the Constitution had been denied her. And I'd put it to you, but I'm not aware of any particular common law tort that would address that. They also, so essentially all that the Minsky case said is in that particular fact pattern, you do have a direct claim under the North Carolina Constitution because there is no other adequate remedy. But with respect to this case, again, I've already talked at length that there is plenty of adequate alternate remedies that have been held to be such by both this court and the Supreme Court. Again, you've got claims against Southern Health Partners, and again, the individual capacity claims against others.
Can you just touch briefly on, I don't want to interrupt, but
Yes, ma'am.
so plaintiffs argue that this provision of medical services is not governmental, and in fact, in this particular instance, it's not governmental, and they cite Leonard v. Bell and Medley v. North Carolina Department of Correction. Can you talk a little bit more about what their allegations are, what their argument is, and why it fails or
Well,
not?
the Leonard case, I think that case doesn't have the slightest thing to do. I think if you look through the opinion, you won't find the word governmental immunity or sovereign immunity at all mentioned in that case whatsoever. All that case was about was whether or not a private contracted medical care provider could claim public officer's immunity against suit. So it really, that would be the same as if Ms. Gray in this case were to claim public officer's immunity. I don't believe she could do that. But that case has nothing whatsoever to do with whether or not the county and the sheriff have and maintain governmental immunity. The Medley case, I think, just stands for the proposition that, that inmates have a right to, not to have a right, but that whether it's the prison system or the jail are obligated to provide them with medical care. But it doesn't speak, I don't believe, to whether or not there's any sort of abrogation of governmental immunity by that case. Again, for governmental immunity to be waived, I mean, the Supreme Court's been clear, you have to be very, very, very specific in the statute in order to waive it. And again, the 153A-453 says you only have waived governmental immunity to the extent that you have coverage for the claim. And there's no coverage for any of the claims here. So I have time left over, but I realize that we've all got places to be and things to do, and so I will yield unless there's any other questions from the court. Thank you.
All right, thank you, counsel. We'll hear from the appellee.
May I have the court's permission also to take off the mask?
You may.
Thank you, Your Honor. May it please the court, first of all, I would like to, just for a record thing, we are standing by our brief, the supplemental statements of authority and the amicus, so we're not, we incorporate that by reference into our argument, so that if y'all should have questions and we don't go through my whole points, that they'll be there of record. Your Honor, first of all, it is a pleasure to be before you live. I appreciate the extra effort that it takes to do that. With all due respect, this case is very simple. You have a situation where a county and a sheriff and 2 officers starved a human being to death, kept them from water. We know that that behavior is egregious. This isn't a situation, as appellant suggests, of one miscue among healthcare. This is a situation where a profoundly mentally ill human being was allowed to die over a long period of time because he didn't get food and he didn't get water. Now, to suggest to this court that there is no remedy against the government, that in this case the county, none at all, they have no responsibility to make sure that a human being under their care gets water and food when that person is completely unable to take care of himself due to schizophrenia and other mental illness. It shocks the conscience that that is what they're arguing, when in fact this same county prosecutes people in their homes or in nursing homes or in other facilities for murder for doing the same thing. So, Your Honor, when you suggested, Judge Dietz, is this about individuals? Is there a difference between a lawsuit that's pending against other defendants? The answer is yes. Although appellant tries to basically just ignore that difference, there is all the difference in the world in terms of the constitutional claims that Quorum and Minsky have talked about, and Craig. What they all say is it is an individual, it is a claim against a particular defendant. In your claim against that particular defendant, do you have an adequate remedy? Not is there somebody else available who you might sue? And that is what, in fact, although the Cosby case is, the Cosby case is unpublished, therefore non-presidential, it says the same thing. In that case, of course, it was an alleged rape, not something as basic as day after day letting a human being who is acting totally like a schizophrenic in a schizophrenic delusional state die because you won't give him water and you won't give him food and you won't put him in a medical facility that can take care of him.
I want to clarify just a couple things.
Sure.
Your argument that sovereign immunity, governmental immunity is unconstitutional, do I read your brief to be arguing that?
You read our brief to be protecting that argument. We understand
Okay.
fully where we are. It's
Okay.
another building that we would have to make
Okay.
that argument to.
All right, great, we are on the same page there. And is this the same argument with respect to the bond and the extent of the bond and the amount that it is waived up to the limit of the bond being
There-
unconstitutional?
Our view is, yes, it's unconstitutional, but there's an important distinction. What we're saying is, as it relates to the bond, $20,000, when you apply the question under Craig and under Minsky in quorum, is there an adequate remedy? That's where you look at the $20,000 bond and say, as it relates to the sheriff, is $20,000 an adequate remedy as a matter of law? The answer is no, because that's the step that you go through is there a culpable claim and is there an adequate remedy at law? Well, for constitutional violations, when there is no adequate remedy, meaning not just the right to sue somebody, but the right to get adequate compensation, if that doesn't exist, then our courts say very clearly what occurs is the constitutional rights trump sovereign immunity because sovereign immunity is judicially created. So it goes to the adequacy of remedy.
Okay, and so, and I posed this question to counsel to your right. If they did not argue that the denial of the dismissal of this direct constitutional claim affects a substantial right, why do we reach that now?
Well, you know me well enough to know I'm going to answer directly, and the answer is it shouldn't be because they didn't preserve it, and it's not up to us as the appellee to tell the other side what they should or shouldn't appeal. Under the way that the Court of Appeals has crafted substantial rights, you have to argue it. It's not intuitive.
And you did not allege that they didn't argue it either, correct?
Well, we didn't, because you have the discretion under the court's rules to do so. And
Well,
we
and
thought it
it's
was
jurisdictional, so you don't have to raise it, right? We address our jurisdiction whether you put it in your brief or not.
Right. So when our view was, if y'all were concerned about it and weren't reaching out to say, okay, under judicial economy, fine. But you asked me the direct question, are you supposed to? The way I read the law, no. But we understand that's discretionary. So since it's discretionary, we shouldn't be telling y'all what the scope of your inquiry is, as I understand it. That's for this panel to decide, unless I'm misreading the law, which is entirely possible. So what we're also saying about the county is when you're dealing with things that are non-proprietary, and Leonard versus Bell says medical treatment isn't governmental, it's proprietary. I mean, you can go in the phone book and there are an endless number of people in Wake County alone who practice medicine. So things that impact the treatment in Wilson County of a person to the extent that it involves medical care, that's not governmental immunity. Besides which, even more basic is you've got to, it's not medical care to give and it's certainly not governmental to give somebody under your care water and food. We say that in any facility. It could be a nursing home. It could be a foster care home. And that's what State versus Cheek said. And that language is, I think, very applicable here on a number of different topics. In State versus Cheeks, they say it was a conviction of first-degree murder by starvation and negligent child abuse, and this is in the private setting. And they say, and this is at Cheeks 858 at 567, paragraph 47. As is the case with acts of torture or poisoning resulting in the death of another person, the intentional withholding of the nourishment or hydration needed for survival resulting in the death of that other person at a time when the other person in question is unable to provide these things for himself or herself shows a reckless disregard for human life and a heart devoid of social duty, and it cites State versus Wilkinson. And they say, put another way, the act of starving another person to death takes time during which the defendant has ample opportunity to reflect on his or her conduct, take mercy on the victim, and to be increasingly aware that the other person's condition with the decision to intentionally deprive another person of needed nutrition and hydration resulting in death being, under such circumstances, inherently malicious as a matter of law. So that has nothing to do with the status of you are acting on behalf of the government. This is a malicious act comparable, the court says, and would support a murder charge. And in fact, according to State versus Cheeks, a murder conviction. And to follow that further, what the county is saying to you is they can go prosecute these same people for murder under State versus Cheeks. They can convict them, but the county would have no liability, absolutely no responsibility whatsoever. Now, doesn't that really sort of boggle the mind?
But there's case law out there where the state has killed someone and been entitled to sovereign immunity, or a public official has killed someone and has been entitled to governmental immunity, right?
No doubt, but the question has to do with, one, to get governmental immunity, you have to be in the status of acting on behalf of the government using the discretion that the court gives you. Then you come down to the question of, if it is something this horrific and there's no claim for relief because the county has decided not to have insurance, then that's where the Constitution steps in and says, no, there's no justice right.
So that's sort of where I was heading, is I'm not hearing you make much of a defense to us based on the existing case law about the determination that all of the claims other than the statutory bond claim are claims for which there's immunity.
Say again?
So what I'm saying is, what is your argument for what was the trial court thinking when it denied summary judgment on the governmental immunity claims? Like, what was the reasoning of the trial court?
As it relates to the sheriff, that's because the sheriff, through its non-delegable duty, was responsible for providing basic care as well as medical care, because this implicates both. You can have a person who has medical needs who still is able to feed themselves. This is a person incapable, because of their delusions, incapable of feeding themselves. And although the court correctly, the trial court level, if there's a genuine issue of material fact, you don't make findings of fact in summary judgment. He shouldn't. Once there's summary judgment, once you've proven you're not entitled to summary judgment, you just deny summary judgment and move on.
So, and what was the reason why these claims aren't subject to immunity?
We say that with the sheriff and sovereign immunity, that the constitutional claims trump it. That, in other words, you get your choice. If you are in a situation where you're violating basic constitutional rights under the Declaration of Rights, and clearly water and food falls within that basic category under recurrence of fundamental rights. I mean, you don't have to go any further than that.
Well, I guess I'm confused though, but that would be an argument of why your constitutional claim would survive because there is no adequate remedy because there's immunity on the other traditional claims that you've asserted here. But my question is those claims, what is your argument? Because the trial court, I am correct, right? The trial court said no, the summary judgment denied on those claims. So
On all claims.
I'm trying to understand why did the trial court think that there was no immunity and that you could not enter summary judgment on that basis on those claims?
The reason I believe the court concluded, and we think properly, that sovereign immunity didn't apply is that on the first step, sovereign immunity doesn't apply to things unless you're acting as the government. If the government enters into a contract to have a amusement park, there's no governmental immunity or sovereign immunity. You have to be doing something that's governmental. And so they don't even get to sovereign immunity just because his body happened to be located in a prison. That doesn't mean that everything that happens to him is an act of sovereign immunity. We're talking about the sheriff now. That is, he is a human being. They are responsible for him under his fundamental right is not to be starved to death, not to die from lack of hydration. So it's not the government exercising a particular discretionary power. There is no discretion involved in whether, am I going to starve this person to death or not? Am I going to let this person die of lack of hydration? There are more ground, if I can jump to the county, there are more grounds as it relates to the county why the judge was absolutely right. The first is, again, under the fundamental duty of the county is anytime they have anybody, whether they're a prisoner or not, as their ward, they have to make sure they're fed. And they have to make sure that they don't die of lack of water. And that, if you recall, in that regard, there was a case cited in our brief that specifically talked about the fact that that's fundamental. It was like 150 years ago. They said food and water is primary. You have to give them you can't leave them outside, for example. That's not governmental exercise. That goes to the very basic, what are called fundamental rights. You have the fundamental right. The county also was, to the extent it was providing health care, wasn't acting in a governmental role at all. It had the contract, and we cite the contract in the brief extensively, and that's at the record page 210, it's a health services agreement. And it says, this agreement between Wilson County, in North Carolina, hereinafter referred to as the county, and Southern Health Partners, and then it describes what the county is doing. That's for health care. That's the same as if you had an agreement with a doctor. A law firm or a business could have an agreement with a particular health organization. They could have specific agreement, like the Carolina Hurricanes could have an agreement with Raleigh Orthopedic. This is just a health agreement. It's not a sovereign immunity situation. And it says, whereas the county is charged by law with the responsibility of obtaining and providing reasonably necessary medical care for inmates and detainees, whereas the county which provides funding is approved by the county. Then, as you go through, they talk about if the county becomes dissatisfied with any health care personnel provided by them, they get to terminate them. That's simply an agreement to provide medical care, has nothing to do with their status as a county. And when they signed on, the county attorney signed on behalf of Wilson County. That's clearly an undertaking. It's a commercial undertaking, and it didn't necessarily have to do at all with any more than if they happen to wanted to provide health services for a county-run school. And there are plenty of private schools that contract with healthcare providers.
So in your view, are you making an argument that there's insurance coverage for any of the claims that you're asserting here?
The county made a conscious decision not to get insurance. Well, that's really their problem, because they made a calculated decision that for things that were not governmental, they would be self-insured. And that doesn't mean you don't first look to insurance to say, well, if a county doing anything at all that it wants to do, any kind of activity, whether it's running an amusement park or anything else, doesn't have insurance, well, we're not going to hold them liable. The insurance portion only relates to whether, when you're acting in the role of a government so that you have governmental immunity, are you then exempted for non-constitutional violations? Because once you get to constitutional violations, then it doesn't matter whether you have insurance or not. So
I was just trying to figure out if your argument on the non-constitutional claims turns entirely on us concluding that these are not claims for which you could assert governmental immunity, or whether you were also saying there's been a waiver on some other basis.
It's really in the alternative but we don't see the county, which it could have done, insist that it get named as a named insured. So what we say is, if that it's non-governmental for this, beyond which they did a specific undertaking, and under the case law that the Hendricks case, what it says is, anybody who engages in an undertaking, once you volunteer to do something, whether you had a duty or not, of course we say they had a duty, once you take it on, it's yours. You can't undertake, for example, to hire and provide medical care to any group of people, and then say, oh well, we don't have a responsibility for that. And that's particularly true when you have a contract that says we do have a responsibility for that.
So we've got case law, lots of it, that says that our courts have long deemed the operation of a county jail to be a governmental function. And so when you look at the operation of the county jail, it sounds to me like then you are breaking down everything that's required to operate a county jail. And do we look at, if they undertake to provide the food, if they undertake to provide cleaning, if they undertake to provide medical, then all of a sudden they have undertaken to do everything that it is required to operate a jail. So sort of where does it start and stop?
Well, it's a fair question, but what you have to do is separate out, we think, things as basic as, do you get to give people poison? In other words, can you go find all the rotten food that exists that's being thrown away and serve it to inmates going, well, we have immunity. And so what we say is the most basic fundamental right is to get healthy food and water, and that's not something that really relates to running a jail. And on page 35 of our brief, we cite Lewis versus the City of Raleigh, and it says, the North Carolina Supreme Court held back in 1877, it said this: what is contemplated by our Constitution and statutes shall be the treatment of prisoners, The least that is required is that they have a clean place, affordable or comfortable bedding, wholesome food and drink, and necessary attendance. This is required for all prisoners. How much more ought to be done, we don't know. So we would say, if you're talking about things like oxygen or food and water, that's not running a jail. Could they put somebody in a place, in a cell that had no oxygen? Is giving somebody air a governmental function? Not under the Lewis versus City of Raleigh case. We understand that in every case, you have to draw a line somewhere. So, and when asked about that throughout the years, because it's not the first time a very intelligent appellate judge has said, Doug, where are you drawing the line? And what I say is, we aren't here to draw lines in future cases. We're here to decide these facts. These facts are basic things, as basic as food that's not contaminated in water. And if you take on the process by which you starve somebody to death, then that is not something that you get protection from. And that was when we. So I'm hope that that's not a circular kind of
No,
argument.
you answered my question.
What I was looking for was, you'll see in the case law that it says, if we don't allow responsibility under constitutional violations, then, and this was the Medley case, the seminal case, Medley says, look, if we do not hold people accountable under the Constitution, then you could have situations where they literally torture inmates without any responsibility. They said it could be, there are some cases where it's lengthy, and it's a lengthy torture to death. There are others where it's not it's bad, but it's not that horrible. Here, you have what is the worst of the worst. You've taken a person, not just a person who can advocate for themselves, but a person who's wildly delusional, who has known mental illness, and then over the course of weeks, you allow this person to lose 30 pounds and to become inhuman. As his attorney said, who had seen him, his criminal attorney, he wasn't even like a person. Well, this isn't a decision that law enforcement makes when they're going down the road and it's a chase, and maybe they're fired up about the chase and they have minutes to decide. This is day after day they see a person acting like an animal. Had they done the same thing to a horse, had they done the same thing to a dog, they would be in jail right now. The fact that they did this in Wilson County Detention Center doesn't make it better, doesn't make it less significant, and it doesn't give the family less rights. And the fact that here we are in 2021, and we're having to say, well, what are the consequences if you starve a human being to death over a course of weeks? It's stunning, really, to come from a governmental institution. And what we would say is the law, Quorum, and Craig, and Minsky say, no, you don't do that. In fact, in the Highway Commission case, early on, the Supreme Court said, if we have to fashion a remedy to make sure that constitutional violations and constitutional rights are protected, we'll fashion a remedy because, as Quorum says, anytime you have a conflict between any form of immunity, whether it's governmental immunity, public official immunity, then the Constitution always trumps because those are fundamental rights. Now, the other thing is they've talked a lot about private, for the individuals, the difference between public official liability and liability on individual rights. first of all, summary judgment was proper, denying summary judgment was proper, because there hasn't been any determination at all about the individual rights claims. In all the cases you see, the individual rights were already the subject of summary judgment and been denied. The court was absolutely right when he looked at it. If they only brought the official capacity claims, then the court had to deny them because there was no indication whatsoever that there were individual right claims that would survive. That hadn't been determined. And I would go back to State versus Cheeks to say, malice is shown by the actions themselves, and that's what Cheeks said. The reason you don't have to get from the defendant, oh, I intended to cause this person to die from lack of water and lack of food, is they say the act itself is malice. You don't need anything more, and that was for a first-degree murder conviction. So are we really going to say you can get a first-degree murder conviction, but there's no remedy? And in that case, it was a private individual who was charged for conduct in their own home, not conduct that were required by the Constitution to provide. I think I'm seconds away. So thank you all very much.
All right, thank you, counsel. Any rebuttal?
And again, if I have your indulgence to unmask. A few points. I don't think there's any question that providing medical care to inmates is a governmental function. It's required by statute. There are multiple cases, the Medley versus North Carolina case, and there's a couple of cases from this court, Frink versus Batten and Slade versus Vernon, all fall under the same facts as this, where an inmate is receiving medical care in either a jail or a prison, and those were deemed governmental functions, and the governmental immunity analysis was made, particularly in the case of Slade versus Vernon and Frink versus Batten, which are consistent with this case. And in both cases, essentially the court found that there was governmental immunity as to all the claims with the exception of the bond claim, which is consistent with our position in this case. So respectfully, the contention that giving somebody food makes it no longer a governmental function, I mean, are we going to get down to beds? I mean, with all due respect, whether or not to provide air, that just seems kind of like part and parcel of doing anything. I mean, government's providing air in this building doesn't make the state of North Carolina suddenly proprietary because we can consume oxygen. So just respectfully, I think it's clear under the law and the cases that medical care to inmates is a governmental function for which governmental immunity will apply. A couple of points, and I apologize for jumping all over. It's a question of law as to whether a remedy is adequate with respect to a constitutional claim. And the cases that I talked about earlier, again, the Taylor versus Wake County case, you've got a county, you've got a state. As long as you have a remedy for that injury, then you have a adequate remedy. And in this case, as I said earlier, Southern Health Partners, all these individual capacity claims, but also to sit here, excuse me, and I don't mean to be pejorative, but to make an argument that, well, $20,000 is not enough, it needs to be more. I mean, frankly, governments make those decisions all the time. I mean, if I get killed in a car wreck on the way home and somebody has minimum insurance, assuming they have any at all, the minimum under the state law is $30,000. My wife might think that's more than I'm worth, but that's what the limit is, $30,000, not far beyond a bond. For our soldiers and Marines that were killed last Thursday, up until 2006, the death gratuity for service members killed on the line of duty was $12,450. It's more now because Congress went and changed that, but that's substantially less, and you could make an argument it's unconscionable, but that's what the law is. So respectfully, the bond is a adequate remedy at law, but we don't even, again, get to that point with regard to the constitutional claims because of the reasons that I said earlier. They have adequate other remedies. there was questions about what the county chooses to insure itself for. Of course, they make business decisions all the time. One thing that they would have been insured for if the plaintiffs had brought that claim was a Section 1983 case, because governmental immunity doesn't apply in that case. But the plaintiffs, for tactical reasons, apparently chose not to pursue that. So it's difficult for me to understand how you can sit here and say, well, you're not insured for this, when there was a claim that there would not have been governmental immunity for, which they made a decision to waive. And then the individual capacity claims, I've already talked about this, but the cases, if you look at it, it doesn't mean that they only get to that after the case has been tried. The cases, and I struggled a minute ago to try to find the one, but basically they talk about individual capacity claims, and if there's public officers' immunity, that issue, that's still an adequate remedy. I think the language, and I apologize to each of you for not being able to find the quote off the top of my fingertips, but essentially the fact that they would have to make an additional showing of malice and intent and things like that, that doesn't make the remedy I guess, inadequate. And finally, respectfully, I have to take issue with the language and the constant argument of letting people die and starving someone to death with respect to my clients. Sorry, I'm having a senior moment, but the plaintiff's counsel, and you can see they chose to put these depositions in the record, but they deposed the 2 detention officers, and they deposed the sheriff, and they deposed other people. And all the detention officers said, we made sure that the nurses knew what was going on. We talked to them all the time. And we let him know that we were giving him food, but that he wasn't eating it. That we were giving him water, but he wasn't drinking it. So to claim that he's being deprived of this is respectfully not accurate. And the cases are clear, particularly in the federal courts, had it been brought, that it's not up to the detention officers to override nurses and medical care. They just have to make sure they get the care, and Mr. Cavanagh's got that in this case. And I see that I'm out of time.
All right. Thank you, counsel. Thank you both for your arguments. We'll adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned. I appreciate your indulgence. I mean, you can see I have a nice scar running down the side of my back. And my son goes to Mount Tabor, where the school shooting was yesterday. So yesterday was